regardless, I'm heartless. Even if I gotta take it, I'll take it. See if it's money out there, I'm gonna make it. I'm gonna make it, I'm gonna make it.
Cause I grind, cause I hustle, cause I grind, cause I hustle.
YouTube, welcome to Backstabber TV, where we have enough drama for your mama. Today's story is about a sneaky, secret squirrel by the name of Lemmy Andrews, aka Young Red, aka Bloody Pimp. Now, a cat like this can prove damaging to a RICO conspiracy case when he's secretly meeting with the government while still attending strategy meetings with other co-defendants and discussing aspects of the defense. Even though Bloody Pimp sat with the U.S. attorney and several special agents, in the end, he still found himself sitting next to OG Mack and the rest of his co-defendants during a 10-week trial. To understand what happened to Mr. Andrews, we have to refer to a term or a statute called a 5K1 motion. We'll go further into the 5K1 motion shortly. However, the government, they may be interviewing several different informants in a single indictment, and so they have the opportunity to compare stories. Or a rat might give info on a person but leave out incriminating evidence about himself. Then the person that he told on cooperates and tells the complete truth. So one lie, one admission of self-incriminating statements or any perceived inconsistencies results in the feds refusing to issue a 5K1 motion. But they can still utilize any information that they received. This is what happened to Bloody Pimp. In the federal system, this is referred to as enemy in the camp. Let's go into a little background about Lemmy. As a youth, Andrews found himself in several youth facilities like Spofford for several bouts with delinquency. He found himself fumbling through life and hopping from Staten Island to Harlem, from couch to couch, trying to find a hustle. Petty robberies, crack sales, in and out of jail, back on the block, on an OR bell. Lemmy ran with a crew from Convent Avenue called the Bald-Headed Murder Men that was ran by a hot-headed shooter named Hedis, who was known to shoot first and never ask questions at all. After Hedis made his way to prison for gunning down a couple of his enemies, Lemmy began hanging with and driving for a well-known pimp, who eventually began calling him his little brother and named him Young Red. After driving hoes around for close to a year, Pimpin' took a liking to him and started lacing his boots about the game. It seemed like the young aspiring pimp had put aside the bullcrap and started getting serious about the game. Moving hoes, turning them out, knocking them off real good. Between 97 and 98, he was pimping pretty fair, staying deep, buying cars and cribs, and traveling across country with his game. He probably was approaching his prime around 99 when OG Mack, also known as Omar Porte, came from prison. For Red, it seems like this was the beginning of the end. It's safe to say that the two was instantly, secretly smitten with each other. Mack controlled the gang, but he was intrigued how Red controlled his hoes, with finesse, no force. In his mind, if he recruited Red, he can control the hoes too. And on several different occasions, Red was warned that pimping don't mix with none of the bullshit. But in Lemmy's mind, it was possible. Back to this 5K1 motion. Now it's funny how the legal terminology is queen for a day when referring to a proffer meeting between a potential cooperator and the government. So most likely on this day fit for a queen, he left the MDC, which is the Manhattan Detention Center, most likely in the early AM with the rest of the inmates going to court. Now the transport usually returns around 5 p.m. However, buses often arrive as late as 9:30 or 10. Now, that's a lot of hours spent talking to these folks now. You know, they fed him lunch from a nearby restaurant of his choice, most likely. And if he stayed long enough into the night, they fed him dinner too. You know what I'm saying? So just imagine the U.S. attorney or two, several agents, police or whatever, and they already have information from the streets and prior investigation leading up to his arrest, and information from other snitches. You know what I'm saying? So they recording every word to compare with their notes. Now, according to Lemmy's case, it's apparent that you can give them tons of information and not receive a 5K motion for a reduction in sentence. And the government can use all the information to investigate and convict others. So when Lemmy Andrews decided to snitch, he wasn't capable of being 100% truthful about himself as he was about exposing others' criminal activity. So basically, after the U.S. attorney discovered these lies, they kicked him to the curb and offered him what he felt was too much time. Now that forced him to go to trial with OG Mack and the crew. So imagine sitting next to this nigga fighting for your freedom. Meanwhile, the government is using information provided by this rat, aka enemy in the camp. Okay, now you know we can't identify an individual as a rat without official paperwork, and this paperwork is going to be available to anybody and everybody who requested or searches for this case number under this situation on Google. So you'll have that information too. This is a matter of public record. What happened was, after the cooperation and after he was denied a 5K1 motion, and then after he went to trial and after he blew trial, he appealed this sentence. And so in this appeal, he was exposed by the court about the cooperation that he attempted to provide but failed to because of the lies that he told and so what and so forth. So, you know what I'm saying? Basically, it would have been a secret situation. Nobody would have had knowledge of this had not he added certain things to his appeal in an attempt to get a sentence reduction. And when the motherfucking courts read him the riot act, you know what I'm saying, they also inserted the fact, basically saying, nigga, we gave you the opportunity to tell. You went and you sat down with the U.S. attorney and you told him whatever you told them, and they was not satisfied with your information, and they found that you was being untruthful, so they did not use you, and they did not issue you a 5K1 motion. And so, you know what I'm saying, you had to do what you had to do. Court papers state, following a jury trial in district court, defendants Omar Porte, Lemmy Andrews, and Gary E. Jackson were convicted of various offenses arising from their involvement with the Bloods gang. On April 14, 2003, the district court sentenced Porte to 50 years imprisonment. 2 days later, Andrews and Jackson were sentenced principally to 352 months, which is about 29 years and a few months, and 336 months imprisonment, respectively, which is about 28 years and 1 week. So OG Mack gets sent to ADX, which is one of the most secure federal penitentiaries in the world. And Bloody Pimp is floating around the federal system acting like a stand-up nigga. You know, his PSI is clean because it does not reflect the existence of a 5K1 motion because he didn't get one. When you snitch and you receive a sentence reduction, it is reflected in your pre-sentence report, which is the PSI. So now he's able to get in the New York car wherever he goes, you know what I'm saying? Hanging around New York cats. He's rubbing elbows with official dudes bragging about how he blew trial. Meanwhile, he a rat. It's a possibility OG Mack and the others might have an appeal issue under the newly discovered evidence. The whole OG Mack, Omar Partey situation is a whole different story. So I'm just going to basically glaze over, you know what I'm saying, certain aspects of it, you know what I'm saying, far as Bloody Pimp's, you know what I'm saying, man, involvement. So let me recount some editorial pertaining to the case. The inner workings of the ruthless street gang, the Bloods, are being exposed in a guarded Manhattan courtroom as prosecutors charge they used violence to control an army of drug dealers, prostitutes, and bandits in the Bronx. The gang leader, Omar OG Mack Partey, who created the gang formerly known as the United Blood Nation, while doing time in Rikers Island Prison in 1993, has been eyeballing juries for nearly 2 months as he stands trial with 3 of his alleged lieutenants. The braided street boss presided over a vicious underworld in which new gang members as young as 16 were initiated with 31-second beatings, supplied with semi-automatic guns in order to bash and kill rivals to gain respect and status, court papers say. 3 others, Gary OG G Jackson, 31, Lemmy Bloody Pimp Andrews, 27, and Deshaun Jabi Foster, 30, are also standing trial after being indicted with Partey last year on a total of 39 racketeering charges. Partey, aka OG Mack 30, is accused of controlling a section of the gang known as the One-Eight-Trey, which rules street crime with an iron fist around the 183rd Street and Davidson Avenue in the Bronx. The convicted armed robber revealed his penchant for settling neighborhood disputes with violence soon after his release from prison in 1999, when the federal blood had a fight over money with a Bronx drug dealer known as K-Born. Prosecutors said that Partey, aka Mack, intervened and told K-Born's associate that any attempt to collect the drug money will result in the use of guns. However, when K-Born assaulted the Bloods member a week later, one of Partey's lieutenants, Lemrey Andrews, aka Bloody Pimp, who was also on trial, allegedly escorted a 17-year-old member of the gang to K-Born's apartment. Using an AK-47 and an Intertech 9mm semi-automatic assault weapon, the pair are accused of pumping 30 rounds of ammunition into the drug dealer's front door. K-Born was shot but survived. Prosecutor Ronnie Abrams told jurors that Andrews controlled the gang's prostitution operations, bringing in women from southern states such as North Carolina to work the New York streets. Foster, aka Jabi, 30, is accused of randomly shooting a 16-year-old, Frank Espinoza, in the face at point-blank range to avenge McCarthy's daughters being slashed in a fight in August of 2000. Victim miraculously survived, although the bullet ripped through his mouth and lodged in his teeth. Then the next editorial states that gang lord gets 50 years for thug life. The founder of the Blood Street Gang was whacked with a 50-year prison sentence yesterday after prosecutors told the federal judge the ruthless warlord was a crime wave unto himself. Let me note that when Bloody Red was arrested, it was prior to Mack and them being arrested, he had caught a gun case in Maryland while they was, you know what I'm saying, participating in shenanigans that had to do with a robbery and all that. He fuck around and told the feds that shit in his motherfucking proffer meeting. But the feds arrested him after that for the instant offense, you know what I'm saying? And at this time, his hoes was left back, you know what I'm saying, in New York, you know what I'm saying, around Mack. So, you know what I'm saying? Instead of letting them hoes do what they knew best, was hoeing, which was a misdemeanor, Mack had them hoes committing robberies and other federal crimes, you know what I'm saying, which was felonies, you know what I'm saying? So, of course, when that pressure came down on them, you know what I'm saying, they testified for the government in the end, doing trial, you know? Apparently, this marriage, you know what I'm saying, between the pimping and the gangbanging was really a fucking train wreck. Yeah, also, you know, normally the BOP, which is the Bureau of Prisons, they never send an inmate more than 500 miles away from the state of conviction, you know what I'm saying? Unless you like a major threat, you know what I'm saying? Or a rat or something, you know? But somehow, you know, Bloody Pimp, you know what I'm saying, he got himself transferred to a prison in California where he, you know, was stabbed 15 times and allegedly sexually assaulted with a blunt object. Obviously, the West Coast Bloods wasn't feeling him, you know? So, you know, basically the bottom line is that, you know what I'm saying, it's not even 100% sure that any of the co-defendants know that this motherfucker Bird was sitting next to him and shit after he done told the motherfucking DA or the federal prosecutor, U.S. attorney, everything under the sun, you know what I'm saying? So, you know what I'm saying, cat like that'll come home with his chest stuck out, acting like, you know what I'm saying, he was a stand-up nigga, you know what I'm saying, and that he did his time and blasey, 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 but, you know what I'm saying, what don't come out in the wash will come out in the rinse. Okay, so, now the information I'm about to provide, it can be located online under certain appeal and civil situations, one being 08 Civil 3325 5DNY March 31st 2009. It cites 2 cases. Also under the United States versus Andrews 254F Appendix times 335 Second Circuit in 2007. These are all cases that could be accessed online, you know what I'm saying, without no payment or none of that. It's all a matter of public record, and it's all available to the public. Okay, so this gives a basic breakdown on Andrews' situation. So now, after his conviction and everything, he went back and he appealed his sentence, and he tried to claim that he had an ineffective assistance of counsel. And on the basis of this, it was about an audio tape that the government made during a conversation he was having with another individual on the facility phone at MDC. Now, prior to him having any conversations, or prior to him going deep into this conversation with this individual, he did say that the phones were being monitored. So he knew that everything that he said was being recorded by the feds. So he went on to say certain stuff. He implicated other people. He implicated Big Pimpin'. He inadvertently made some admissions about himself. Just a bunch of, you know what I'm saying, bullshit. But then somehow, when the government provided this tape to his defense, it was blank. And so they didn't get a copy later on. You know what I'm saying? And so now, in his appeal, like he forgot that he did a little talking. In his appeal, he states that if he had had the tape, and if he had realized what he had said, and if his attorney had advised him properly, that he would have cooperated with the government, you know what I'm saying, and pleaded guilty like the rest of the rats. But I don't know if he thought that his cooperation was a secret from the courts, or, you know what I'm saying, or the appeal judges, because, you know what I'm saying, they came back with, wait a minute, You were afforded the opportunity to cooperate. You attempted to cooperate and you failed because you provided false information. And so they basically just blew him up, you know what I'm saying? And so whether or not his co-defendants knew about the cooperation, obviously they didn't because they sat right next to him. Later on now through the appeal, they can find out that Andrews cooperated with the government. Now let me read some direct commentary from the plea decisions and legal pleadings. Andrews eventually charged along with 14 co-defendants in a 31-count indictment on May 7, 2001. Shortly thereafter, Andrews explored the possibility of serving as a cooperator. On June the 7th, 2001, the government interviewed Andrews pursuant to a proffer agreement in the presence of his attorney, Copeland. During this session, Andrews admitted, along other things, that he transported women across the state lines for the purpose of prostitution, that he assaulted and manipulated these prostitutes, he utilized the Bloods to provide protection for his prostitutes, and that he had obtained a firearm in North Carolina that he was used during an attempted failed robbery, and he offered information about other individuals. After the proffer session, the government advised Mr. Copeland that the government was not interested in negotiating a cooperation agreement with Mr. Andrews. So, on August the 27th, 2001, the government sent Copeland a draft of a proposed plea agreement, which contemplated a sentencing range of 151 to 188 months, but did not provide for cooperation. Andrews rejected the offer and opted to proceed to trial. After 9 indicted co-defendants pled guilty, jury selection commenced in the trial of Andrews and 3 others on June the 10th, 2002. On that date, the government notified Andrews' defense and the court that it intended on playing a portion of the audio tape that contained the call made by Andrews from a prison to an unidentified male on June the 2nd, 2001. While the government had turned over copies of more than 60 audio tapes to the defense, approximately a month before trial, Copeland reported that the government had given him a blank copy of this. So now after they get a portion of the tape and they listen to it, blase, or whatever, you know what I'm saying, down the line during the appeal, Andrew states that he would have cooperated if he had heard the tape prior to trial, and that he would have, you know what I'm saying, went on and cooperated and pled guilty and snitched, but they blew him up. Buddy, you already did, you know, so that's what this is all about. Court goes on to say, it's clear from the record then that approximately 9 months before Copeland received the blank tape from the government rejected Andrews' potential cooperator, and Andrews rejected the government's proposed plea agreement. Thus, the subjective prejudice is without basis as clearly established by the documented record of the pretrial plea. Fool, let's explain this Queen for a Day, or this proffer meeting. The purpose. A proffer is a meeting between a criminal defendant and or suspect and the government that usually takes place at the local U.S. Attorney's office rather than at court. At the proffer, a defendant is represented by counsel and the government is represented by the prosecutor along with investigating agents. The meeting is typically covered by a limited immunity agreement where the purpose is for the defendant to share with the government all verbal, written, or electronic information such as emails, statements, documents, videos, photos, or records that may be of use to the government. The disclosure of information. The defendant is expected to share with the government everything they know about the crime in question and the people involved during the proffer. The defendant is legally required to tell the truth and not withhold any relevant information. A proffer is unique in that the defendant essentially incriminates themselves by openly talking about both their role and their knowledge of the crime committed. They must not minimize this involvement nor exaggerate roles or the roles of others. By no means should a proffer be misunderstood as an opportunity to blame others and to present oneself as an innocent bystander. This is an approach that is reserved for a trial. Under untrue statements, if it is later found or learned that information provided during the proffer is inconsistent with information, evidence, arguments, and representations received by third parties, the proffer statements may not be used against the person who made the statement during trial, but the government would use the proffer information to rebuke or refute any information being offered by the witness with the goal of impeaching that person via cross-examination. In such a case, the government will introduce the proffer information as evidence against the defendant at trial. The government may also use the proffer information at the sentencing hearing if the defendant has broken the agreement in the proffer session. And so that's basically saying that if your ass take the stand, we gonna blow your ass up about shit you said in the proffer meeting. So that would make him not testify. And also, they can turn around doing sentencing, which is what they did. You know what I'm saying? And soccer to your ass about shit you told him about yourself, buddy. Benefits to a defendant that Mr. Andrews did not receive states, benefits to a defendant, a proffer agreement is not a promise of absolute immunity, but agreement between the defendant and the government for a certain level of used immunity. A proffer can offer a door to making someone a cooperating defendant who may be eligible and 100% truthful. Preventative use, and this is pertaining to the use of the information that's provided by cooperators, whether they are used or not. The government may make derivative use of information during the proffer, as established by Stiger versus United States, 1972. This essentially means that the government may pursue any investigative leads suggested by any statements or other information provided by a defendant from the proffer. Such derivative information may be used against defendants in any future proceedings. The Stiger waiver associated with proffer letters allows the government to both pursue and use these leads without having to later attend a hearing where it would have to justify the use in the results of the defendant's proffer information. Also highlights the risk of a federal proffer agreement. In a situation where it is later revealed that information that was provided during the proffer is not consistent with evidence, arguments, or information that was received from other witnesses, then the proffer statements could be used against the defendant or suspect at trial to impeach him in the event of any cross-examination. Yeah, so what's your verdict, YouTube? Should all the co-defendants receive a new trial? Was the government wrong for using Andrews' information to convict him while refusing to give him a time cut? You decide. Meanwhile, like and subscribe. More videos on the way from Backstabber TV. Until then, take a chill pill.